Hello, I'm Patricia Louise Nelson, attorney with Two Spruce Law in Bend, Oregon. I want to talk to you today about the difference between a full probate and a small estate proceeding. A full probate is available to any estate, regardless of how little or how big it is. The small estate proceeding is only available to certain estates in Oregon. So, if anyone can do a full probate, why would anyone do a small estate proceeding? Because it's cheaper and quicker. So you might ask, what are the rules for a small estate? Well, let me tell you. In order to qualify to do a small estate in Oregon, the real property, that's land, home, improvements on the land that are attached to it, have to be worth $200,000 or less. And everything else, bank accounts, cars, investment accounts, gold bars, collections, everything else has to total altogether $75,000 or less. So even if your estate qualifies for a small estate proceeding based on those limits, you may still want to consider doing a full probate for several reasons. One of the reasons we do a full probate, even if the estate qualifies for a small estate, is if the estate needs to sell real property. Under Oregon law, to sell real property from a small estate, we have to have every single heir sign the deed. Call our office for help in figuring out who the heirs are. But sometimes the heirs are too young to sign a deed. Sometimes they're spread all over the globe. Sometimes there's an uncooperative heir. Bear in mind, an heir needs to sign the deed even if the heir is disinherited under the will and won't receive anything. So there's no reason for that person to cooperate. If you find yourself in the circumstance of having to sell real property and you're thinking about doing a small estate, double check that it will actually work for you. Another important factor to assess in determining whether to do a full probate or small estate is whether we know, or we're pretty sure we know, all of the creditors of the person who died. As a general rule of thumb, there are exceptions. In a full probate, we tell creditors to come to us. In a small estate, we have to go hunt down the creditors and notify them. If we leave out a creditor in that process, we have to start the process over. So it's really important to consider how confident we are that we know who the creditors are before we start down the small estate path. Well, a really significant reason to do a full probate, even when we qualify for a small estate, is whether there are what I call unusual circumstances in the estate. A small estate proceeding is designed simply to transfer ownership of assets to the people who are going to own them next, subject to the listed debts. There are no other powers in a small estate. It's simply a conduit. A full probate, the personal representative, has all kinds of powers to evict people from the real estate owned by the estate, to force people to turn over assets they're not being cooperative about, to settle disputes among the heirs or beneficiaries. So if you're anticipating that there might be that kind of potential conflict in your estate administration, really it's important to consider doing a full probate instead of a small estate proceeding, regardless of the value of the assets. And the last reason I can think of right now for a reason to do a full probate instead of a small estate is if you're concerned that another person who is interested in this estate might want to swoop in and take over the administration of the estate, don't do a small estate proceeding. Under Oregon law, if we start with a small estate proceeding and another interested person files a full probate for the same deceased person during the first 4 months after we file the small estate with the court, they take over the estate administration, and what we've done means nothing. So if you're concerned about what I call an estate takeover, don't do a small estate. Give us a call. Let's walk through these factors and see if we can figure out what works best for you.